welcome to Legally Speaking with me, Tarun Nangia. Today we'll speak of a law which is called the Prevention of Money Laundering Act, and the possibility that this law may drive out investors, and also a lot of businessmen may fear to invest in India or commit more funds because there is a very big difficulty in getting bail under this law. There are also other issues related to attachment of property and possession that we'll also discuss in the show, and many other problems and defects, as we may call, with the Prevention of Money Laundering Act. Why I am saying so, why this is a problem, and why a lot of businessmen may stop committing funds to India because of this draconian law, we will get to know today from senior advocate Amit Desai. As we all know, he's one of the top members of the bar in India at the Bombay High Court and the Supreme Court of India. Also, we know that he is representative, if I name the top 5 or 6 industrialists in the country, or maybe a bit more, he's representing them all at some point or the other. That makes him the fit candidate of explaining to us not only the legal but the sociological perspective why this law is so damaging to society and why this law can, in a sense, hamper investments in the country. May I welcome Senior Advocate Amit Desai and thank him for joining us today. Thank you so much.
Thank you very much for Tarun for having me over.
And at the outset, the biggest hue and cry about this law, the Prevention of Money Laundering Act, is the twin condition for bail. Why this is a problem, can you share with the audience, and why this law is in a sense draconian?
So Tarun, the twin conditions, actually there's only one of the conditions which is really draconian within the twin conditions. And that is the condition that when you apply for bail, and I think most of your viewers would know what bail is about, when you apply for bail, you are required to demonstrate that you are not guilty of the very offense for which you are being currently investigated. And as you can understand, and this is more a commonsensical issue, that at the arrest typically happens at the commencement of the investigation when all the record and evidence is being collected. At that very stage, when you arrest a person, to expect him to be able to establish that he is not guilty, that's the language used in the section, establish that you're not guilty or prove that you're not guilty, is next to impossible because of various reasons. Firstly, all the records which are relevant to prove your case are now part of the records of the investigating agency because they've been seized and taken over. The second is that you are sitting in custody. These are very complex financial transactions which are typically investigated by the Enforcement Directorate under the provision of this Act. To expect at that very initial stage within the first 1 week, 10 days, 15 days, or 20 days, that I am not guilty would require a kind of a mini trial, but must require access to all the documents which the authorities have actually taken over and they are scouring through them. And you must have access to the documents and then establish that you're not guilty. This is just next to impossible to do. And by the time you finish, the investigations get over, you get access to the document, it takes years. So it's a very, very difficult situation when you're dealing with the question of bail with a condition which says that for securing bail, you must establish that you're not guilty of the offense of money laundering. So this actually is a serious problem in this legislation. And this entire legislation being, in a sense, an economic crime or economic offense. I mean, you can imagine it's all a matter of a series of myriad banking transactions which are relevant, which are, transactions undertaken very often in the ordinary course of business, but undertaken by employees of a company, and to get all the vouchers and get all the underlying contracts for which the payments have been made. I mean, it's impossible to do it. So therefore, from a very realistic perspective, to have a provision like that is extremely draconian in a legislation of this particular type. And this legislation, as you know, typically tends to target the business community because it's an economic offense.
Now, suppose you catch a businessman, you arrest him under the Prevention of Money Laundering Act. From what you say, I understand that the judge has to record a finding while giving him bail within 24 hours of his arrest that he is convinced that he is not guilty. So which means before he's been sent to trial, the judge must be satisfied that he is not guilty. Don't you think that this is absurd?
It's a very difficult situation. In fact, I might tell you, the power of arrest, which is another draconian power in this particular legislation, because the arrest and the bail actually go hand in hand. Now, whilst the section which deals with the power of arrest says that the power of arrest can be exercised only when the officer, like the director, deputy director, assistant director, has reason to believe that he is guilty of the offense of money laundering. There also the language is guilty of the offense of money laundering. So you have a very senior officer who, when he exercised the power of arrest, has determined your guilt. You're then taken before a court, and then you're expected to satisfy that judge without any records that you're innocent. I mean, it's so absurd a situation that it is actually a kind of a pre-trial detention, which is not permitted under Article 21 of the Constitution. You have a whole different concept of preventive detention under Article 22 of the Constitution. But bail is never, ever a matter of preventive detention. But this is what is the outcome of when you read these two provisions in conjunction, and the ground reality of these two events. The outcome is that it is like a pre-trial detention.
Now, very interestingly, it does not stop at that. A businessman arrested in the money laundering case many times won't get bail for 1 year or maybe more, but that's not about it. There is a problem about attachment of property. Sometimes a year, you're arrested for a money laundering case, but your ancestral property has been attached. What is this issue? Can you decode it for the audience?
So I'll tell you the power of attachment. I mean, there's a logic to the provision for attachment. And essentially the logic is that if there's any property which is a subject matter of the offense of money laundering, then obviously the agency should have the power to attach the property before it dissipates itself. So you have a power of attachment. Now, the question that arises is that how do you exercise that power of attachment? For what purpose do you exercise the power of attachment? It's very difficult for authorities in that initial period of few days to really determine that the property is involved in money laundering. But it requires a lot of forensic investigation also in order to determine that the property is involved in money laundering. But what is happening is that the moment the agency sees some property of an accused who has been arrested, the first thing that they would do is go and attach all the properties. Now, when they go and attach the properties, they're rarely looking at the age of the property. When did they acquire the properties? Was it from tainted funds? Was it from untainted funds? And we've had situations where, and I've had one particular situation, which is a stark situation, if I might give it as an example of what does happen, is that in one particular case, we found that property that had been acquired by the company, which was in manufacturing, it was the factory land, was a land that had been acquired by that company sometime in 1911 by that particular company. Now, the company had changed hands over a period of time and then ultimately was owned by the businessman who had been arrested. But when they went to attach the property, they attached a property that was with the company from 1900s, early 1900s, when there was no, pre-independence period, there was no legislation, there was nothing. Now, these are, of course, stark cases, but this is where the question is, how do you exercise the power of attachment? Where do you draw the distinction? And a lot of this impacts business, because when you start going after the business community and you start attaching the assets of the business community, you're also attaching the assets of the business themselves. And when you start attaching the assets of the business themselves, it has some serious repercussions for the business community. Because, there are stakeholders, there are employees, there are so many other people who are in that business. You effectively bring that business to a standstill.
No, very interestingly, the enforcement directorate, as you said, can attach a factory, can attach a house, which have no connection with the case. If a crime has been committed, money laundering only happens if that money has been used to create another asset. But the enforcement directorate can attach some ancestral house, or in violation of law, or the law allows, you will share with us. But secondly, they say they can also take possession. How does that work?
So once the property is attached, then if it is mobile property, then it can remain where it is. If there are tenants or occupants, then they can remain in possession unless the tenant or occupant is somebody who is from the family or who is not paying any rent, in which case that property has to be handed over. So if the gratuitous licensee, then you must vacate the property and hand it over. But if it is earning rent, then of course the rent has to be paid over to the enforcement directorate. Movable property, which is from bank balances all the way to shares in a demat account or mutual funds, all of them are required to be transferred into the account of the enforcement directorate. They start taking possession of it. And obviously, as you know, the law under the Depositories Act, etc., is that prima facie, the shares are owned by the person in whose name they stand.
But tell me, if a businessman's accounts are attached, for example, how will he run his house? Because
serious livelihood issues, Tarun. Serious livelihood issues. Because the legislation does not provide for an exception that matters amount for the livelihood of the accused should not be attached or should be available to him. There's no provision for it in the law.
And we have seen in a few cases that if the money laundering case is about 2,000-3,000 crores, properties worth multiple that amount have been attached. How does that work?
So initially the properties get attached and there's a valuation that is supposed to be done. And the property that's attached should be equal to the amount of the offense of the money laundering, typically. What happens is that every time when they look at valuation, they often look at cost and not at the market value. And that changes the complexion because the cost of many of these assets are obviously because they were
So
acquired.
basically, you mean to say for a small violation, lot of property or almost everything can be attached.
That's correct. And I'll give you another problem about the attachment of properties, Tarun. Let's assume that the Money Laundering Act is being utilized for the object for which it is meant to be. Let's make that assumption for a moment. One of the areas is in many of these matters is that there are a lot of creditors. You take a lot of these large cases which we read about in the press. There are a lot about bank defaults. There are lots of creditors who are involved in it. Now, the object of the legislation is then to attach the property so it's available for the benefit of the creditors. Now, in many of these cases, these very properties which are attached constitute the security of the lenders. In some cases, not the security of the lenders. But if you attach the property, then the lenders take a long time before they can get repaid. So the question for us to consider is there a wire media? And I'll give you an example of a very high-profile case as an illustration in point as to what can be done. Today, you have this high-profile case of Nirav Modi. They attached the business, they attached the diamonds, they attached the brand, they attached everything. Okay, the crime has been committed, he has to face the consequences. But the property was required for the repayment of the creditors, namely the Punjab National Bank and the consortium of banks. If this very business, and there was value in the business, if this very business was taken over, like they did in the case of Tech Mahindra in Satyam, where the business was actually taken over despite the very serious crime, and then they were able to actually pay off the stakeholders. If the business was taken over because there was a viable business, and that business was then sold over to somebody else who had the ability to run the business, you would have retained value, created a lot of value, and the banking sector would have actually recouped a lot of its monies much faster. Today, you can see the banks running around through the legal process to recoup its dues.
Very interesting.
How do you bring that balance into the system?
The promoter is thrown for a year in jail.
Right.
In fact, his company may nosedive and the accounts may become NPA because he's the one who was running the company.
That's
you
right.
threw him in jail. Now his family life and also his business is in a mess.
Yeah.
All hopes of banks of recovering money will finish if the man who runs it is out.
That's right.
Because,
so these are problems which we are seeing, Tarun, in several cases. And I don't want to name the cases because they're all sub judice. But we do see these problems in several cases where the ability for the banking sector or the lender to recoup its asset or its dues is diminished, or it takes a much longer period of time there because of the proceedings which have been initiated under the provision of this act. So there is a need for bringing about some kind of a balance so that the creditors actually get their money much faster rather than...
Very crucial. So the PMLA law does not even affect the promoter and his business, but the bank loan also gets affected and NPAs may happen because of these cases.
That's correct.
This is a very crucial point. I'll take a short break and we'll be right back to discuss the sociological impact and some more problems with the money laundering law or the PMLA Act. just before the break, we had Senior Advocate Amit Desai sharing with us how NPS can result when a promoter is put in jail for an extended period of time. Of course, we all know when the promoter is put in jail, all the directors, the management, the senior management get scared. Business, for all reasons, can't happen the way it was. And so, of course, the capability of the business to pay its loans also gets affected. Now, I'll move a bit ahead and let me ask Mr. Desai this. If you can share with me that money laundering case is not the first case. First, a police case is filed and the ED reference happens. Because if in the first crime, in the second, if the laundering has happened, then there is a PMLA case. But if you're acquitted in the first crime, then does the money laundering case automatically you get acquitted?
So it's not automatic. There's a very interesting crime which has been constituted by this act. It is actually a crime of laundering which is predicated on an offense which has been committed, and some money has been derived from that offense which has been committed. So when that money that is a property that's derived from an offense which is committed is actually, which is a tainted property, is laundered and made untainted, that is the offense of money laundering. Now, is typically, and what we have been arguing before the court, and that's something that the court needs to decide. The Supreme Court is now seized of this particular issue, is that if the predicate offense has closed down, either because the agency found that no offense was committed while they were investigating the crime, or that through a process of a trial there's acquittal that has happened, then should the money laundering offense continue? There is a divergence of opinion amongst the courts. There are many courts which have said that predicate offense is a precondition for the money laundering offense, and therefore if the predicate offense ceases to exist, then the money laundering offense must also automatically drop.
I want to ask you, if somebody robs a bank and keeps the money in one room, that does not become money laundering. You mean that it has to be turned into a property or something for it to be money laundering?
It has to be, yeah. So the concept of money laundering typically is that you take the tainted money and you, through a process of layering, what they call placement, layering, and then integration. The ultimate objective is integration into the main economy is when the property is laundered. So that is the entire process, and that's the offense of money laundering. So if you, as you gave the example, if you rob a bank, you take away a gold brick, you keep it in your house, and that's not laundering, that's just a crime of theft. But if you take that brick and you make an effort to try and deal with it and dispose it off, and the proceeds of that, you kind of integrate it into the stock market and you buy shares, then that is the process of laundering for which there's the offense of money laundering.
So basically in India, there is also confusion between money laundering and plain robbery.
That's correct. That's a very serious issue that has been debated, it's been argued at great length. And once the Supreme Court determines, we'll know exactly how the contours of this money laundering section.
So I want to come on the sociological perspective of this crime. Do you feel that this, in a sense, has put fear in businessmen, and because they are scared, they may not commit more funds, which will to make new factories or create employment, because whom we are throwing in jail, many of them are job creators. Many of them have built big businesses. We need businessmen in this country. So you think that, okay, some crooks are caught, but a lot many are also acquitted, because acquittal rate is pretty high in such cases, as we see.
Yeah, so I think, the one of the biggest examples of acquittal is the 2G, which started off with a 176,000 crore scam and resulted in an acquittal at the end of the day. So I think, here also we have to balance off. There is a Money Laundering Act, and that's a special legislation. Then there's the ordinary legislation. A lot of people may be caught under the ordinary legislation, whether it's a penal code, whether it's a customs act, whether it's a SEBI act, what have you. You may be caught under that, but merely because you're caught under those legislations, and so many businessmen, somewhere or the other, willy-nilly may have committed some wrong contravention, deliberately or inadvertently, but it may be one-off. But they are caught under that legislation. Now, they will face the consequences for those crimes and the contraventions that they've committed there. But what happens is when they come under the Money Laundering Act, because of the draconian provisions, namely the power of arrest, the bail conditions which are there, the power of attachment of all their assets, all that they've created over a time as businessmen is then all washed away, because then they're sitting in jail. A lot of their assets are being attached left, right, and so the morale of the business is not there because the promoter is sitting inside jail, and it's next to impossible to come out because of this particular twin condition, in which case the business itself is impacted.
When we want to build an economy, say a $10 trillion economy or even more, do you think such laws need to be refined so that, you make them good? That is what I want to ask you.
I think the real challenge, Tarun, that we face is about the implementation of the law. I think the law started off with a very laudable objective. I don't think that there could be any doubt or debate of the objective of the law. It started off with a laudable objective. I think the question today, because of the possible language issues that are there and interpretational issues, it has created a deep sense of fear, because some of the statistics which I saw presented to the Supreme Court yesterday is that there were 1,700 raids and barely 9 convictions that have taken place in this history of the PMLA, which is and most of them are all these business related crimes. So certainly it has created a deep sense of fear amongst the business community that what business people may think to be legitimate business activity, which may result in an NPA, may, on a subjective assessment of the facts, result in an offense of fraud or cheating to be registered by the CBI or by the local police, and which triggers the whole money laundering investigation. Now, I must tell you that so far the CBI is concerned, they do not effect arrests in the manner in which some of the other authorities do, including the PMLA. They do a very detailed analysis of the facts, a very systematic analysis of the facts, and then at the end of the investigation, they file a charge sheet. In rare cases, maybe 3 or 5% of the cases, they would actually effect an arrest. But the arrest that they effect is under the general law, and therefore the ability to get bail is under the general law, and there's no twin condition. But when it comes to PMLA, there's a draconian provision which comes in, creating a deep sense of fear in the business community. So over a period of time, when you listen to people who come in with all these problems and others also, they're very concerned. They're very, very concerned about this legislation because of the manner in which it is currently being implemented. So I think the real issue today is make the legislation workable, make it work in a manner where there's a balance between the needs of the state in relation to a legislation like money laundering for its primary objective and the needs of the business community, who may commit mistakes, who may commit some crimes, but there is ordinary law which can deal with those crimes, and which is what has been happening for the last so many decades and centuries. So even before our Money Laundering Act happened, we did have the Customs Act. In the 60s and 70s, soon after independence, there were so many cases of smuggling under the Customs Act. But they were still able to deal with the problem. Business still continued. In fact, Customs Act now has a compounding provision because they felt the importance of the Customs Act as a part of the economy. So they introduced compounding in Customs Act. You have SEBI. Now, it's a very interesting situation where I can give you an extreme, which is that under SEBI, Section 24 of SEBI is part of the scheduled offense. Now, what is Section 24 of SEBI? A breach of the Act, rules, or regulations is an offense under SEBI. So this covers the entire gamut of every single regulation under SEBI. So take, for example, to take an extreme example, there's a contravention of the takeover code. It's not yet happened, thank God. But just to demonstrate that there's a contravention of the takeover code. You can technically say, on the basis of which the law is currently being applied or interpreted, is here is a predicate offense because there's a contravention of the takeover code. The ECR can be registered. And soon the question is that if we go along this path, I will start attaching target companies. Why? Because of the contravention of the takeover code. Now, can you imagine what it does to the economy, what it does to the capital markets? Now, you need to find a balance between these legislations to protect that very economy for which there is a SEBI, whose primary role is to protect capital markets, protect investors. They will do their job when it comes to contraventions of the provisions of SEBI. But you need a situation where merely in those kind of contraventions, you have the PMLA authorities diving in. I can understand a situation where if the market is being used for laundering funds which are coming from illicit sources, then I understand that there's a need to target that. But if this is a predicate offense, SEBI is a predicate offense, then all that you need to do is to say, okay, this is a contravention of the regulation. I triggered PMLA. Because that's the way the law is currently working.
So basically, you say that if we have to protect our economy or even grow it, then the twin condition for bail must go in that sense. Attachment and possession should be relooked at in this law. You cannot take possession.
And also take away some of the predicate offenses which are essential to protect the economy, or explain that only if they are linked to money laundering activities, then only you can bring them within the scope of the PMLA. But not
One
just.
Final comment for you from your side on the show before we end it.
So as I told you, Tarun, this legislation was introduced to protect, as the preamble says, to protect the economy of the country. And I only say one thing about the manner in which we are seeing some of these activities, that it should not happen that this legislation destroys the very economy that it seeks to protect.
That's
really the issue for us to consider here.
That's beautifully put, as only senior advocate Amit Desai can put. On this note, we end this show, but we will revisit this issue with senior advocate Amit Desai because there is a light at the end of the tunnel, and that time is not come. We await. Cases are going out in Supreme Court on this issue. Maybe in a couple of months or maybe earlier, there may be some judgment, some order that we look forward to. What happens is what the whole country is watching for, because it involves not only the business community. A lot of people work in businesses. They have their families. Only when businesses invest are jobs created. But that's it for today. I would like to thank Senior Advocate Amit Desai for sparing time and joining us for this very important issue. It was a pleasure to hear you today. Thank you so very much.
Thank you very much. Thank you for having me again.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.